Hi, my name's Chris Nolan. I'm a barrister at Queen Victoria Chambers in Sydney. This video is called Police Search Powers and it's designed to assist legal practitioners in the local court of New South Wales. In the notes below, you'll find a link to the associated paper. So police in New South Wales have the power to detain and search people, but only in very limited circumstances. If you can persuade a court that that search was unlawful, the court then has a discretion to exclude the proceeds of that search under Section 138 of the Evidence Act. So it's very important that you understand the circumstances and the test that allows police to stop and search citizens. So Section 21 of LEPRA gives the police power to detain and search any person if they, quote, suspect on reasonable grounds, unquote, one of the four circumstances that are listed in Section 21. And those four circumstances are, firstly, that the person has something stolen or unlawfully obtained. Secondly, that they have something that has been used or intended to be used in connection with the commission of a relevant offence. Thirdly, that the person has a dangerous article that is being or was being used or in the connection with the commission of a relevant offence. Or lastly, that they have a prohibited plant or prohibited drug. The leading case in the matter is called Rondo. I'm going to tell you the factual scenario of Rondo, and I want you to have a think about whether the police had reasonable grounds in these circumstances. Mr. Rondo was a young man in a very expensive car, and this brought him to the notice of Highway Patrol. They pulled him over, and when he stopped his car, he put something into the glove box of the car, and they felt that he was trying to hide something, put it out of their sight. And they felt that this gave them a reasonable suspicion that he had some contraband on him, and they exercised the power under Section 21 of LEPRA. They found in the glove box, they found drugs and money, and Mr. Rondo then made it worse for himself by trying to bribe the police. He said to the police, you see what I've got here, can we work something out? Meaning, you take the drugs and the money and I'll go on my way. Now the police refused that offer, and they arrested him and charged him with supplying drugs and dealing with the proceeds of crime. Now Mr. Rondo pleaded not guilty on the basis that, and defended the case on the basis that the search was unlawful. He was found guilty. He appealed to the Court of Criminal Appeal, and the Court of Criminal Appeal considered the circumstances and said, firstly, that a young man in a flash car is not grounds for a reasonable suspicion. They said that there's lots of young people who drive their parents' car or another family member's car. Certainly that's not suspicious, and that did not give the police the power to stop and search him. They also said that finding the drugs and the money could not make the search lawful retrospectively. They said the test is, at the time they decided to make the search, did they have reasonable grounds or grounds for a reasonable suspicion? The fact they found drugs and money afterwards is irrelevant. The search doesn't become legal. An unlawful search doesn't become legal because they find contraband, and likewise a lawful search does not become unlawful because they don't find contraband. And finally, they said that the attempted bribe was irrelevant. It also could not retrospectively make the search legal. So Mr. Rondo's appeal was rejected, but it became the leading case in New South Wales because Justice Smart reviewed all of the authorities relating to a reasonable suspicion, and he boiled it down to three propositions, which are found in paragraph 53. I'm going to read them to you now. The first proposition was that a reasonable suspicion involves less than a reasonable belief, but more than a possibility. There must be something which would create in the mind of a reasonable person an apprehension or fear of one of the four states covered in Section 357 capital E, which was the old Section 21 of LEPRA. A reason to suspect that in fact exists is more than a reason to consider or to look at the possibility of its existence. The second point that Justice Smart made was that a reasonable suspicion is not arbitrary. Some factual basis for the suspicion must be shown, and a suspicion may be based on hearsay material or materials which may be inadmissible in evidence, but the materials have to have some probative value. The third proposition is what is important is the information in the mind of the police officer stopping the person or the vehicle or making the arrest at the time they did so. Having ascertained that information, the question is whether that information afforded reasonable grounds for the suspicion which the police officer formed. In answering that question, regard must be had to the source of the information and its content, seen in the light of the whole of the surrounding circumstances. So at the beginning of the hearing, there will be a voir dire, and that's a special sub-hearing in which the magistrate will determine whether the search was lawful and whether he or she should exclude that evidence under 138 of the Evidence Act. And during that voir dire, they'll have to answer 2 questions. The first is, what information did the police officer have in their mind at the time they made their decision to search the person? And then secondly, whether that information is sufficient to ground a reasonable suspicion of one of the 4 states stated in Section 21 of LEPRA. So you'd put your police officer in the stand and get him to say what he understood at the time of the search, and then you'd make your submissions, and they'd go something like this. May it please the court, the burden falls on the police to prove that they had reasonable grounds to suspect one of the 4 circumstances in Section 21 of LEPRA at the time of the search. In my submission, they have failed to discharge that onus. The fact that they found contraband in my client's possession cannot provide those grounds retrospectively, nor can my client's criminal antecedents be sufficient grounds. If it were, then my client could be subjected to arbitrary searches on a daily basis. It is a long-standing tenet of our law that a person's body is inviolate. The customary companions of arrest are ignominy and fear, and a police power of arbitrary arrest would be a negation of any true right to personal liberty. In my submission, the police officer did not have a reasonable suspicion, and the search was a violation of my client's civil rights, which this court has sworn to uphold. I further submit that, in the context of the case, the undesirability of admitting the evidence obtained in this manner far outweighs the desirability of admitting the evidence. Now I'll give you a real-life example of a case of mine earlier this year in the Downing Centre. My client had been stopped and searched by the police, and they'd found both drugs and stolen credit cards. Now, when we ran the hearing, I said to the magistrate up front, there's no dispute as to the drugs or the credit cards. It's simply a challenge to the search. So we'll have a voir dire. At the end of that voir dire, I will make a submission that the search was unlawful, and I'll make an application under Section 138 of the Evidence Act. The magistrate was very happy with that. He said, just a voir dire. I said, just a voir dire. He was very happy because I wasn't putting the police to proof. I was conceding, making reasonable concessions of certain facts, and laying out up front exactly what the issue was going to be. So the officer in charge got on the witness stand. I allowed him to tender his statement, and his statement was to the effect that someone had called the police station and said that someone was stealing a bicycle outside the Woolworth. He ran on down to the Woolworths and he found my client with a bicycle. Based on that, he stopped my client, and he spoke to him. He said my client was acting nervous and possibly drug affected. He got his name and address. He radioed that in and found out he had a criminal history for goods in custody and drug possession. And at that point, he searched my client and found the drugs and the credit cards. So I then cross-examined him, and I said to him that basically the bicycle wasn't stolen. He said the reason you stopped him was because of the bicycle, and I pointed out that this was not the basis of your suspicion. You didn't think he had a second bicycle in his pocket, did you? And he said, no, the bicycle wasn't stolen. That was just according to my notice. I then put to him that he stopped lots of people in his career, and no doubt all of them were very nervous when they were talking to the police, and he agreed that yes, they were. And I suggested to him that my client was not drug affected at the time, which he said no, he definitely was. And I said that the real reason he'd searched him was because of his criminal history. Once he'd radioed in his name and address, the report had come back about his criminal history, and I said that that was what. It's only after you received that information that you decided to search my client. He, of course, denied that and said, "Oh no, it was a mixture of everything. It was the bicycle, it was his nervousness, his drug affected state, and his criminal record." And I put that was the end of the evidence. At the end of the voir dire, So that was the end of the evidence, and I put to the magistrate that there was no reasonable grounds to search my client. The real reason he had done so was because of his criminal record, and that was not a legitimate reason to stop and search my client. The magistrate agreed. And the real issue then was the Section 138 application, whether the evidence should be excluded. And he asked the police prosecutor, look, this is drug possession. This is the lowest possible drug offence. Why was it so urgent that they had to violate this man's civil rights? The police prosecutor did her best, but ultimately the evidence was excluded and my client was acquitted, even though he quite obviously did have the drugs and the stolen credit cards on his person. Thank you for your attention.